Welcome all of you for this medico-legal symposium, and all important aspects are covered in this particular symposium. Our chairman, Dr. Deshpande, has prepared this presentation, but he had to leave yesterday because of the emergency situation. So on his behalf, I am presenting this topic, that is New Consumer Protection Act 2019, difference from old act and its effects. So he is the medico-legal consultant and chairman of legal committee of AIOS and Maharashtra Ophthalmological Society also. The Consumer Protection Act, it is applicable. Hello? It's just one slide before. Yeah. Applicable from 20th July 2020. So service means service of any description which is made available to potential users and includes but not limited to the provision of facilities in connection with banking, financing, insurance, transport, processing, supply of electrical and other energy, telecom, boarding or lodging or both, housing construction, entertainment, amusement, or the viewing of news or other information, but does not include the rendering of any service free of charge or under a contract of personal services. So old jurisdiction versus new jurisdiction. Like in district commission, it was the coverage up to 20 lakh was awarded. And now it is up to 1 crore. That is the worst thing. The limit depends on bill paid. This is good thing from our point of view. But no limit of demand even more than 1 crore. State commission in the past it was from 20 lakhs to 1 crore and now it is from 1 to 10 crore. National commission in the past it was above 1 crore and now it is more than 10 crore. So this is the worst thing in new Consumer Protection Act. The effect is, as per new act, the limit is dependent on amounts paid by the consumer and that limit is 1 crore. So luckily one thing is that most of our bills are less than 50 lakhs. So that is the good thing. But then the compensation has been increased. So all cases in which patient has paid the bill less than 1 crore will be lodged in district commission. That is the thing. That is practically all cases will go to district commission. Jurisdiction for lodging the case. In the past, in the area of cause of action, that is district, state or national consumer redressal commissions area as per their limits. So suppose you are practicing in Delhi, probably that particular area. Now you are in Delhi and patient is from Chennai, patient can lodge the complaint in Chennai. So new, at the cause of action or at the place of residence or workplace of the consumer, that is patient. And again, the worst thing is it can be online, so easily accessible for the patient. The effect will be the patient can lodge a case at his residence or place of work. So a patient of Chennai taken treatment at Delhi can lodge a case in Chennai and doctor has to run from Delhi to Chennai all the time for all the hearings. He can lodge the case online also and then doctor can answer online. So easy accessibility for patient. Old provision, there was deposition of 25,000 was required and limitation period for appeal was 30 days. New provision, deposition of 50% ordered amount, that is the change, and limitation period of appeal is 45 days. Appointment of judges, there is some difference. Old provision, the judges and staff was appointed by judiciary. New provision, that is clause 29, the judges and staff will be appointed by central government. The qualifications and other details will be decided by central government. So what is the effect? The doctor may require to deposit a big amount if the district commission has ordered a heavy compensation. Suppose there is crores of compensation asked for by the patient and unfortunately it goes against the doctor and he is going for the higher court. Still you have to deposit that amount. That is the worst thing. And suppose the result is after many more years, there is no interest given to that doctor. But you have to make provision of depositing that money into the court. So appointment of judges, the genuine judiciary judges may not be appointed and then the decisions may be affected. New clauses, that is, if the complainant is not heard in 21 days, then it will be taken as admitted. This is again the new addition. After first hearing, the complainant will be referred to mediator. That is a new provision. So there will be dalals the people in between, they will approach doctors and hospitals and ask them, okay, we'll settle the matter, give us the money. So consumer mediation cell is a new thing which is added and which is the routine according to the court of law. All the cases will be admitted and will be sent to mediation. So that choice of mediation will be given to each and every case. Again, few of the new clauses. Any terms of contract which are unfair to consumer can be made null and void by state or national commission. Product liability action may be brought by complainant for defensive product, that is service. The effect will be any terms of contract which are unfair to consumer can be made null and void by state or national commission, which may be dangerous for the doctor or hospital. That's the thing. Then up till now, negligence was the only one cause for ordering the damages. Negligence, that was the only thing which was under consideration. Now what has happened? The services of any doctor or hospital may be labeled as defective and substandard, and damages may be ordered. So it is not only negligence, but few things are added, and that's the new provision. So the Central Consumer Protection Authority, to be known as the central authority to regulate matters relating to violation of rights of consumers, unfair trade practices, and false or misleading advertisements which are prejudicial to the interests of public and consumers, and to promote, protect, and enforce the rights of consumers. Next, clause 15, that is investigating authority. The central authority shall have an investigation wing headed by a director general for the purpose of conducting inquiry or investigation under this act as may be directed by the central authority. So effect will be Central Consumer Protection Authority, RAJ, will start by inspecting any hospital suo motu, worst thing to happen, and lodging cases against them. So, Inspector Raj, and I think with all these things, what I've tried here, there is a new things which are added in this new Consumer Protection Act 2019, getting worse and worse for medical fraternity, and hope all of us shouldn't be in that particular trap. One important thing which was the rumor probably, because of CPA 2019, people felt that medical fraternity and doctors are not under CPA. But that was a rumor. Because in the list of exclusion, which is given by the parliament, in the list of exclusion, medical fraternity and doctors are not written. So unless it is written in the exclusion list, doctors and hospitals are not under the purview of CPA. Like you are still under the purview of CPA. Remember this. For that, the pains should be taken by higher authorities like AIOS and IMA, and ask the government to exclude medical fraternity and doctors from that list. Then and then only medical profession will be out of CPA 2019. Thank you. Thank you so much.